Hi everyone, so in this video we're going to be looking at the Meriton Apartments case, and this is quite a short video, so hooray for us. Alright, so the Meriton Apartments case was included in your readings because it shows that where parties have expressly provided for some events and not others, it may lead the court to make conclusions about where the risks should fall. So we'll see in this case that because the parties had assigned some risks, they were assumed to have actually assigned by implication, other risks, such as that a development or a land wouldn't be available for this particular development to go through. But this will now make more sense once we actually start the PowerPoint. All right. So in terms of the facts here, there was the sale of a suite of properties near or that backed onto Centennial Park in Sydney. There was an intention that the site be redeveloped into commercial apartments. The contract itself was subject to council approval for the development, and that approval was actually received by Meriton Apartments within the time frame. So the contract was all good to go. However, the project became subject to a green ban, which prevented the development. And Meriton then declined to complete the contract, and they purported to rescind on the basis that this particular green ban, the thing that stopped them developing the site, was a frustrating event. And note as well that the contract was actually silent on the subject of green bans. Okay. So at trial, the judge said that the express provision for one risk, so the non-approval by council, meant that other risks were actually to be borne by the parties. Meriton then appealed to the New South Wales Court of Appeal, where they were ultimately unsuccessful. They then failed to complete, and the other party sought an order for specific performance. And there was ultimately this further appeal to the High Court. Note that the main issue in the High Court appeal was around title, okay? But there is this discussion of frustration in the judgment, which you'll know because you will have read the case by the time you listen to this case video. There is this discussion of frustration, which is why it's been included in your reading for this week. Now, in terms of what the High Court found, they actually agreed with the trial judge, and they found that the land was they actually agreed that the land was substantially diminished in value and not able to be used for the purpose that it had been purchased, but they said that the contract itself wasn't frustrated. And the reason being was that the availability of the land for development was not a condition in the contract, and there was no basis to imply a term. So here the condition reason was that the development consent would be approved by council. So because they had that condition in it, that was the condition, okay? But the availability of land for development itself wasn't a condition of the contract. Now, what this meant was, in practical effect, was that the risk was left to be borne by the respondent, that the land wouldn't be available for development, okay? All right, so if we have a look at our case rating questions then. So the first question was, on what basis was the purchaser claiming that the contract for the sale of land had been frustrated? So this was what we just mentioned, so on the basis that the property had become subject to these green bans. Okay, so in terms of the second part of the question, how was the value of the land affected by the green bans? The value was affected because unions in the building industry opposed the land's development. You can see the description of this at 673 of the judgment. Now, in terms of the second question here, which I guess is the more substantive case reading by question, so why did the court reject the purchaser's frustration claim? Okay, and if you've already had a look at the BCC case, you'll get, I guess, some hint of the answer there. Question 5 of the other case was group projects agreed to purchase the land from the owner, vendor. The completion of the purchase was expressly subject to approval of the plan of subdivision. Before completion, the Crown announced its intention to resume the land as of the date after the contractual date of settlement. Would this announcement excuse group projects from having to complete the project? So we'll go back to our question at hand. Okay, so in terms of answering this question here, so why did the court reject the purchaser's frustration claim? Here it really comes down to the fact that the only risk contemplated by the contract was that the development should be approved by council within a particular time. So that clause was there and that clause was met. And then nothing else was dealt with in the clauses themselves. So, in terms of answering this question then about, whether the risk had been assigned or not assigned by the parties, etc., central to the court's reasoning was the purpose of the contract, okay? And the purpose of the contract is for the sale of land, so it didn't include the actual development. And if you have a close look at 678, you can see this reasoning in action. So, that says the green band. That should actually say the land. Oh, no, that's right. The green band substantially diminished its, i.e. the land's value, and prevented the use of the land for the purpose for which the purchaser bought it. But this is not enough. Availability of the land for development was not a condition of the contract, and there is no basis on which a term to that effect could be implied. So the contract stipulated that the development should be approved by council, and that was the one risk that was to be borne by the respondent, leaving all the other risks to be borne by the appellant. Okay, and I think if you remember back, I may have used those terms the wrong way. So just keep that in mind. So the risk to the respondent was the risk that the development wouldn't go through. So the respondent being McLaurin and Tait. Okay, whereas all the other risks were to be borne by the appellant. So all the other risks were to be borne by Meriton. And here, unfortunately, the green bands was borne by them. Okay, all right. So just in summary, this really shows us that even if a contract is silent on a particular issue, the court may still interpret a particular event to be within one of the risks that was already assigned by the parties. So where parties have expressly provided for some events but not others, it may lead the court to make conclusions about where the risk should fall, which is what happened here. Okay, thank you.